Awesome. Okay, let's get started. Well,
Okay, so my name's Cory Cottam. I'm an attorney. I've been an attorney going on 9 years now. Just brief introduction to me. For the first 3 years of practice, I was in private practice over in Springville. Did a little bit of everything, and then my office burned down over there.
oh my,
So at that time, I was doing contract work with Morrison Law Group, just kind of doing ghostwriting for them, filling in for hearings with them. At that time, Theron Morrison was trying to get me to come on full time with his office. But I enjoyed the lifestyle of being my own boss, doing my own thing. So I continually was turning him down. When my office burned down, he said, well, hey, why don't you come use this office space I have in Sandy until you figure out what you're going to do. That turned into us kind of merging my firm into his partly. I have a unique situation where I work for Morrison Law Group doing bankruptcy, debt defense, foreclosure defense work. But then I also have been allowed to retain my other practice and do business planning, estate planning, contract review, work like that. So it's kind of unique in the legal field to be allowed to work for a firm and still maintain a separate firm. So it's kind of cool that way. In talking with Eric, we were just talking about times when real estate kind of crosses over with what I do with bankruptcy, debt defense, and divorce. So we thought it'd be a good idea to come and chat a little bit about those two areas of law and how they kind of mesh together sometimes. So I'll just chat briefly about divorce and then primarily bankruptcy and debt defense stuff. That's what I'm dealing a lot with in real estate transactions. And then I brought a sample headache I'm dealing with now. Yeah.
Do you want to go ahead and let's introduce Andy?
Oh, sure. Yeah, sorry.
Sorry, I know.
All
You're gonna do this.
right. This is Andy Young. And
She looks young, doesn't she?
and Andy's training to take my place. And that'll happen over the next while. Anyway, but Andy's a licensed agent and she's been licensed for 5 years. So she's got some background knowledge. That's great. And anyway, you'll just get to know her over the next little bit. And
Awesome.
I'm still around. And so anyway, we're excited she's here and we're excited. She was very excited to come to work for us. So we're like agent excited. Yeah, skills. Okay, we're good.
Awesome. Okay, thank you. And
Sorry to interrupt.
No, totally fine. So just as I'm going through this, the same thing I tell my clients all the time is if you have a question, just feel free to interrupt me. I'd rather answer the question up front. If it's something I'm getting to, I'll say we're getting to that, but I'd rather answer your questions now. So as I thought about divorce and how it interacts with real estate, a lot of that's on the legal side. So I won't spend a lot of time there. But what we're seeing right now is with the inflated housing market where homes that were purchased 2-3 years ago for $300,000, they're now worth $600,000. If somebody's getting a divorce and you're having to split that equity, mom who hasn't been working, no way can take on another $150,000 loan to buy out husband for his equity. Likewise, if mom doesn't get home, and this is just one scenario, there's no way she can go out and purchase a home or even rent a home with that. So that's one of the struggles we're dealing with the inflated housing market and divorce is there's all this equity, which is great, but how do we liquidate it to people who need to keep the home and be able to maintain it? So something to be aware of is if you do have a seller client who's going through a divorce, just make sure they're being realistic with numbers. If mom says, well, I'm just going to buy it out or whatever, that may not be a realistic approach.
first question would be how?
Exactly. And that the first and hardest question is, how are you going to afford to maintain this? So the rest of what I thought about on divorce is really on the legal side, getting judges to buy off on creative approaches to that, taking more out of retirement accounts, things like that to get that equity. But
Interesting.
yeah.
So on the capital gains, let's
Mhm.
say they bought it 2 years ago, now that a year later they're divorcing. Is that impacted at all in a divorce situation? Let's say they have no children and the judge says, you have to sell this.
Mhm.
Can, there's no special
As long as, they're-
consideration for the capital gains.
yeah, as long as they're outside the 2 years. the
But if
2-year
they're
capital gain.
in,
If they're inside the 2 years, then no,
no,
it's still gonna be a net gain,
okay,
so.
So the best way for them is to just sell the home and collect the equity that they've learned and at least get some
Mhm.
cash out of it for each of them, right?
That typically, yeah. The issue that I deal with a divorce client is now how do they go and find a place to rent
That they can
Right.
now afford.
Qualify
Yeah.
for a big loan.
Well,
or qualify, yeah.
what are some of the things you do when it comes to like the woman doesn't work or whatever? And, you know, traditionally, I feel like the woman would have a few years to live there. Or whatever.
Mhm.
So how are you handling that?
So one area is getting less of what they would have got out of a like retirement account division.
Mhm.
If there is a hefty retirement account, normally they would get a 50% of that retirement account that had grown.
Right.
But now instead of getting that, it'll be offset with, okay, I'm gonna keep the equity. I'm gonna keep husband's share of the equity. You're gonna keep more of the retirement.
Okay.
Keeps her in her home, but she may be short,
Mhm.
you know, that 150,000, 200,000 that would have been set aside for a retirement.
But it goes either, yeah.
Yeah, it
so-
goes either way.
Okay,
The hard thing for us as attorneys is, especially if we represent mom in this hypothetical,
Mhm.
is you need to now go and make money because you don't have a retirement, things like that.
And in
So-
a divorce, then, if they're both joint on the loan and they get divorced, does the
Mhm.
woman have to refinance it and put it in her name, or can she keep the loan and mortgage in her own name?
It's up to they can negotiate that.
They can.
Usually they'll have a year to 2 years to refinance it out of their name, out of the other spouse's name, because as you guys know, now other spouse is gonna be able to get a new mortgage for a home. But typically a judge won't be like, you have 30 days unless there's income and stuff that can support that.
And then I have a lot of people that call me like right when they're filing for divorce, so they still have a few months to go and say, I need to buy a house. If they buy a house when they are still married but going through divorce, does that become part of their assets that then need to be split? Or can they buy a house on their own outside even if
Mhm.
they're still married?
Yep.
Okay.
Yes, they can. So typically from when you're looking at marital assets, you go from the date of separation forward is no, even though they're still married, those assets. So you can go buy a car, TV, whatever, those aren't going to be considered marital assets.
But if they use cash down payment that was part of their marriage, they'd have to talk to a judge before they use that for cash or something.
Or have a stipulated agreement with the other party that says, okay, we're getting divorced, you need a place, you can use that. It's probably gonna come into the settlement negotiations later on as far as, okay, we took 40 grand out of our savings for you to have a down payment. Where's that gonna offset in my column later? But yeah, you can do that.
That's,
Wow.
yeah, I got that.
Yeah. So, any other questions on divorce or that? So, I tend to, we have an associate in one of our other offices that does our divorce stuff, which I'm thankful for. I finished my last divorce probably 6 months ago, and I haven't entered in on one since, and I've been so happy. So,
But that's the other experience of job experience, you know,
Yeah.
actually know what it was like.
yeah, not my personal divorce, just the,
but when you
Um,
first said that, that's what I thought.
yeah. I had some
Practice there.
Yeah. So, anyway, but more of what I wanted to chat about is the bankruptcy side of things. Because there's a lot of situations with where we're at and everything. The gate of bankruptcy is gonna flood soon. Our firm is one of the highest volume filers. We file about 500 bankruptcy cases a year. And we're expecting, everything's pointing to the recession, credit card use is up, foreclosures are up. Pre-foreclosures are up, everything like that is indicators that we're going to get flooded with bankruptcy stuff. So what that means for you guys is, if you have a client who's going to sell their home and they're in a bankruptcy, number one, I'm sure you guys all know that has to be approved by the bankruptcy court. One of the issues that I run into with real estate agents is they think it's a quick turnaround. And so I'll get calls and say, okay, we're closing on this next week. How do I get my approval? Well, we need 30 days to get it approved. So one of the things, like as an agent, if you have a seller client that's in an active bankruptcy, is to contact their attorney personally as soon as possible. So if you've got a client they're gonna sell, they say, hey, I'm in a bankruptcy, contact the attorney. The attorney's gonna be so grateful that we're spearheading it up front. And in a minute, I'll go over this nightmare case that I have right now of that didn't happen, and now we're trying to salvage dollars at the last minute. But for that to happen, I'll just go over briefly how we do a motion to sell real property. The first two documents that we need from the real estate agent is we need the signed real estate purchase contract. And that purchase contract has to include a third-party approval addendum in it, because the bankruptcy court has to approve it. And I tell you guys that because that's our loophole to get our clients out of a real estate purchase contract if it's a bad deal, because it's required to have that third-party approval.
Sneaky.
Yeah,
That's a UCAR form. Is that in our UCAR form?
I'd imagine it would be. I know when it's listed on the MLS, there's a spot that you have to mark, but I don't know where it's at on the.
Third party,
Correct.
it's just like you would with
Right.
seller or whatever, same thing.
Yeah.
Okay.
So that needs to be included on there, and I just tell you guys that just more or less so that you a layer of protection.
Well, that can be very important if we don't do it, it can be
Yeah.
very damaging, so thank you.
Can I go back to your projections when it comes to bankruptcies and all of that? Like in the real estate market, pre-foreclosure or foreclosures are up, but it's only compared to absolutely nothing
Mhm.
in the last few years, right? So like numbers can be skewed.
Sure.
Like the credit card debt you're talking about, are we looking at, I haven't known that. I thought that there was a lot more saving going on the last 2 years, but has credit card debt gone up a lot?
Well, the reports we get are from bankruptcy data
Okay.
stuff and from creditors that report to. So I'm a member of it's NACBA, the National Association of Consumer Bankruptcy Attorneys.
Okay,
So they report to them so that we know.
yeah,
But yeah, credit card usage is up quite a bit. I should have grabbed those numbers. If you want, I can
it'd be
email
interesting to
those to
see,
you.
and not just like in the last 2 or 3 years, because that's not like fake world, right?
Uh-huh.
But like the last, 5 or 10
Yeah.
years or something, to see
Mhm.
sort of where we are. That'd be cool to see
Yeah.
that data.
Along with that, same data I didn't mention is debt collection lawsuits in the state of Utah
Mhm.
are up tremendously. Again, compared to the last 2 to 3 years,
Right,
but we used to send out 500 to 800 letters a month for lawsuit, and last month we started sending out like 500 a week. so-
wow,
Because there's, well, you guys know there was a moratorium on rentals or on evictions.
right,
Once that lifted, and debt collectors were like, for one time, they were actually smart and put everything on pause for
mhm,
2 to 3 years, and now those upticks, people are defaulting on credit cards, payday loans, things like that. which-
wow.
That's not good.
So still after fashion from
This is
COVID
so
change,
interesting.
not
Mhm.
necessarily the current market.
We've
situation.
been in
Yeah.
our little bubble.
Yeah,
We're more equity in homes than ever, and it's not gonna happen like in
Yeah.
2008. Because there's so much more equity. But if their credit card debt's high,
yeah.
that offsets their HELOC right there, and
Mhm.
Wow.
Well, and I was listening to a report a couple weeks ago that said nationally, the savings has gone down by half. So if people had in the last year, so
Yeah.
if people had like 8,000 in savings, now they're down, they're really cutting into their
They're close-
savings.
Closer
account.
to
So-
4 to 5, and a lot of that is there's a lot to it, during COVID, people used savings to offset either if they got laid off or if they had to take an extended leave. I had COVID for 6 weeks. Fortunately, I didn't have, yeah, and it was the most miserable. Fortunately, I, didn't have to do that, but, I have a lot of clients who, if they miss 2 weeks unpaid,
Mhm.
that's why they become my client, because they were previously paycheck to paycheck.
Wow.
But as far as home ownership, we have seen foreclosures come up. I don't know if you guys know the firms that handle the foreclosures, but they're getting a lot more referrals now to start doing them.
Wow.
So, and with interest rates going up, getting that second mortgage or whatever may not make as much sense now
Mhm.
to offset the debt.
Hmm.
So, anyway, the other document that we need when we do the motion to sell is an estimated closing disclosure. And that's one that the answer I always get is, well, we can't get that for you, but you can. And then just because we have to show the bankruptcy court how much money the client is getting at the end, because the trustee is going to review to make sure creditors get the most out of that. And that's where some of these other numbers come into. You as an agent, you have to be appointed by the court to represent the client as a real estate agent. You have to be appointed by the court. It's done through, it's basically a motion to appoint a professional in there.
How do you get on that list?
So it's, it is. I wish it was just a list, but each transaction you have to be reappointed. With our office, what we do is we include it in our motion to sell real property. We include it within their just motion to appoint the professional real estate agent.
So would you say it's mostly a formality that we have to have you do for us? Okay.
Yeah. So with our office, that's how we do it. And then you also have to supply an affidavit of disinterest saying that you're a disinterested party in the transaction. That and just full disclosure, our office will charge the real estate agent anywhere from $0 to $500 to do that. And we base that entirely on, is this agent going to be a pain to deal with? And I'll just be completely honest with you, because
We do that.
It's not an attorney.
yeah,
Quid pro quo then.
yeah,
My other question, as a real estate agent, if we call you, like you said, with that purchase agreement and someone's going through bankruptcy, are you billing our client to talk to us?
it depends.
That's what I'm saying.
So if I have a real estate agent, that calls me and they're like, this is the client, we're selling the home and we're getting ahead of things, and I don't have to correct things or push things out, then we're not going to bill that because it's going to be efficient. Yeah. But if I have a real estate agent that calls me and says, hey, we're closing in 2 weeks, yes, my client should notify me as well. But then it never fails, that's the agent who emails me twice a day. Can I get an update? Where are we at? We're trying to close. I can do it in 10 days, but I have to do it expedited and I have to do extra motion work, things like that. And so that's why I say, if you have a seller client who is in bankruptcy, contact the attorney up front, and it's going, we can get it done within that regular closing time frame of 30 days.
Well, that's good to know.
So,
Thank you.
and then when you're doing that, so one of the other things that we're running into right now is agent wholesalers buying just in distressed market. But the sale has to be for market because the judge has to approve it and the bankruptcy trustee has to approve the sale. So unless the creditors are getting paid 100% of what's owed, the trustee's not going to approve a wholesale. And that's one of the scenario I was dealing with prior. It's great, and I'm not knocking real estate wholesalers because there's a lot of money to be made there. But if you come in and you're undercut, purchasing for less than value, and other creditors could have received that difference, the judge will order that the house be marketed for at least 30 days so they can make sure that the creditors are getting as much money as possible.
Good. That
Yeah.
should be.
And it should be.
Well, and they really should be wholesaling out of property at this moment, maybe later, but right now.
Yeah.
You still have a lot of equity to earn.
Right.
Yeah. And that's the issue I'm gonna chat about with this one. So, on the motion to sell property. If you contact us, if you contact the attorney up front, we can get it smoothly done within the same 30 days and you don't have to tell your buyer. You know, we have to extend for this, that, or the other. As long as everything's disclosed up front, it goes through just fine.
I've been on the buyer's end and it was a nightmare. It was it totally blindsided me.
So you had a buyer that was in bankruptcy?
Yeah, but everything was done, right? Everything was done. We're fine. We can close in 30 days. It took us another, remember the break? It was a nightmare and and then they had, I guess something else finally came back up.
Yeah,
And so he was, my buyer was gonna be homeless. He was getting out and it just took up like a whole nother 30 days. It was,
so when you have a buyer that's in a chapter 13 bankruptcy,
no, the buyer was buying a bankruptcy.
oh,
So
he was
the
buying
sell-
a home out of,
Yeah, so the
Yeah.
seller was, and his agent said, everything's fine, it's all clear. So as a buyer buying a home that's in
Mhm.
bankruptcy, what do we need to know as the buyer's agent? Because we got blindsided, is what I'm saying.
number one is that has to have court approval if they're in the bankruptcy. And some agents don't realize that, so I'm glad you guys all did, is that court approval has to be done. But as soon as the order from the judge is signed, you should be good to go.
Yeah, it took
Do you
30
know
days
what
for
the,
that.
do you know what the holdup was?
It took, because it showed that something hadn't been paid, but it had been paid, but they couldn't find proof that it had been paid.
Hmm.
And
That
so
makes
nobody could find the proof of it being paid, and so the judge wouldn't sign off on it and I was the one that was calling every day.
Okay, so primarily,
I was squeaking, it just didn't make sense.
No.
The other agent didn't really, I don't think she did any of those things.
and it may have been, I was gonna say, it may have been one of those on the other side that they didn't review everything before, and that's why even if you have a client, even if you can contact the attorney before it hits market, we can avoid all that stuff. On the buyer side, I know it can be frustrating, especially if we can't get a quick hearing or if a hiccup does pop up. So a lot of times what I'm doing for my clients from the other side is if they were having to pay like 100% back to all their creditors, or they didn't have enough funds to pay it all back, I'm going to go through and I'm going to spend time reviewing all the claims that have been filed in their case and see if there's any I can have disallowed or anything like that, so that I can get all their numbers to work. That may have been what was going on. The big issue that we run into on some of that stuff is like tax liens, because they'll put it on both documents. It'll be on the estimated closing disclosure as a tax lien to be paid, but it's being paid through the bankruptcy as well. So we have to get those numbers cleared, because if they've already been paid, we need it removed from the closing disclosure. But if there's still a balance, we need to update that so that they're not. And the IRS and the tax commissioner are happy to take 2 checks, and then I get to spend the next 60 to 90 days trying to get one of them back. So, but typically, as a buyer, just be aware, if you have a buyer that's buying one out of bankruptcy, just let them know, we can't do anything until the judge signs it. There's often not a lot that the buyer can do unless they're willing to
Seems
put
like just
money up.
forewarning the buyer that there could be issues and problems and don't do anything to expedite, or you may not be able to.
Yeah.
It's good advice.
So I had we were selling one out in Vernal. The buyer was eager to buy it. He was trying to flip it for an Airbnb. It was a condo. And we were fighting a $12,000 judgment lien on it. And the buyer was just, I explained to him this could take 45 to 90 days if I have to get a hearing on it. He was just willing to pay the 12 grand because he was getting a deal on it. Wiped away the judgment lien just to get the house sold. And now I'm litigating that to get that 12,000 back for that client because it was a wrongful lien.
Oh my God.
Paid it up front.
He just paid it up front to close and then hired us to go in and sue and get the money back because it was a wrongful lien, but he wanted to expedite the process.
Smart, really.
So, yeah.
Made some good money on the sale.
And so there's times where thinking outside the box will really help move things along and really put money in the person's pocket, everybody's pocket quicker. So. And the other thing to know is buyer or seller side is people get frustrated with the trustee, the bankruptcy trustee. But the bankruptcy trustee's job is to make sure creditors get as much of a return as they can out of assets, sell of property, things like that. So people will get frustrated. Well, why does the trustee want all this money? Or they won't approve this, sell at this if the market's this. It's because their job is to make sure creditors get paid as much as possible. So it can be frustrating, but they're just doing their job. I'll go to this and then over here. So if you have another scenario that I've run into that are good referrals for me is if you have a potential client who wants to buy a home, but they can't get pre-approved or something like that. They have good income, but their credit might be bad. Bankruptcy is can be a quick fix. The reason why is even if we put them in a chapter 13 where we restructure all their debt and they're going to, even if they're going to pay back 100% of what's owed, 18 months, or I tell my clients 18 months. Once they've made 12 on-time chapter 13 plan payments, they will qualify for a mortgage.
Wow.
Quicker than they would have had they taken a year to pay down debt and, clean their credit up. The reason why is because we put them in an approved plan, they make their payments, 12 on-time payments. The mortgage industry now considers them good for it.
I had a client that did that and it was 2 years out before they could get.
So chapter 7 is 2 years.
They did the 13.
So chapter 3, so the law, and I can quote, I can send you the
That'd be
the
awesome.
link on this, is it's after 12 on-time payments
Uh-huh.
in a chapter 13. I always tell my clients 18 months, just because sometimes lenders or underwriters, and I don't get into all that, won't count the payments until their case is confirmed.
Uh-huh.
Technically, it's payment 1. Some say that it needs to be confirmed and there's no hard line law on which one. From what I've seen, it's just what the underwriter comes back with. So if their case took 6 months to confirm and then they need 12 months, now you're at
That makes sense.
18 months. Most cases confirm within 3 months.
Mhm.
So that's why I tell my clients 18 months. But
So the underwriter has a discretion of how many payments they want to collect to count 12.
yeah,
So it's a good thing maybe to consult with the lender and find out how to run this.
yeah.
And pick a different lender.
Yeah. Yep. So again, the rule says 12 on-time payments in a row, obviously. But some don't count it till it's confirmed.
Wow.
So, but even doing a chapter 7, which is liquidation bankruptcy, where you're not restructuring the debt, their creditors are just getting paid whatever the trustee can get from the creditor or from the debtor. It's that there's a 2-year wait period on a chapter 7, but that can still be a better option than, trying to rebuild your credit and then buy 3-4 years down the road versus that. Usually we'll do a chapter 13 because we're restructuring things, and at that point their income is
So say again, in chapter 7 takes how long to clear credit?
2 years.
And that's after discharge, correct? After it's been.
On a chapter 7, yeah. Yep.
You can buy a house after 2 years of bankruptcy.
Mhm.
Yeah, it was
Or
always
7.
7.
7 years.
So it reports on credit for 7 years, but that doesn't automatically disqualify you for bankruptcy
Can't reclaim.
for 8.
Yeah, my ex-husband's done like times.
Oh, so you know all this.
Yeah.
Yeah,
That wasn't my
Possibly
client.
another mortgage, you can do it your way, which isn't quite chapter 7 in 18 months. Otherwise, you're looking at 2 years
mhm.
but it's on your credit for 7 years.
It'll report, at the bottom of your credit report, it'll say chapter 7, discharge this date.
Okay.
But like with my clients, after they get their bankruptcy, we're the only firm in the state of Utah that does this. So after our client gets their discharge, we give creditors 60 days to stop reporting on the credit they're supposed to by law. Then we pull our client's credit and we make sure that everybody's in line with the law. And then we work with them on rebuilding their credit post bankruptcy.
Wow.
We get them connected with a company called YI Budget that helps them learn budgeting skills, how to rebuild your credit, like which credit cards are good. Start with a secured credit card for 6 months, then move into these certain cards that are going to help rebuild And we teach them to be responsible with credit rather than just, here's your discharge, now go out into the world and mess up
And
again.
do the same
Yeah,
thing
so-
again. That's
Yeah.
why 3 bankruptcies. He really
So-
learned his lesson.
One was a business, one.
And then, and I do have, I have clients, a few that are repeat clients. Sometimes we have to be strategic in the things that we do. But primarily our goal is to not just get the discharge and be done. We try and work with them so that they don't come back
That's
to
nice.
us.
Yeah.
So,
Huh.
but yeah, bankruptcy, so, and I had never really thought about that till I was talking to a mortgage lender and he's like, I've got a slew of referrals for you. These are people that we can't qualify right now. And it's gonna be quicker for them to go through a 13, get buy a home in 18 months. And so it's very helpful.
But they have to, I mean, in 18, you do the thing where they can actually qualify for a mortgage, but their credit would probably still not look very good at that point, right?
They're probably over 600.
Okay, so
And
they
it-
get like they're not looking super stellar, but they are
Mhm.
to a place where they can.
Yeah, but I don't even pretend to know much about the mortgage industry other than
Mhm.
I have one and I help people on this. But when somebody's going, if you have a client who's in bankruptcy like that, on the other side, they have to do a motion to incur new debt to be able to buy the home. Because the court and the trustee want to see that this is a responsible purchase. So when I see those interest rates and things like that come through, their interest rate 18 months into chapter 13 is pretty in line. When I bought my home, I got like 2.8, I think, on my interest. And I was approving somebody in bankruptcy at like 3.1.
Wow,
So I'm like,
Huh.
so
that's crazy.
the impact is not,
Wow.
and you know what, remind me we have some books
Okay.
on myths about bankruptcy. I might just bring some down and you guys can,
Put them under the library.
yeah.
Thank
Because
you.
those are the things that people they think, oh, I filed bankruptcy, I can't go buy a house, so they've rented for 6-7 years, well, they could
Yeah.
have bought 4 or 5 years ago.
Wow. that's
So-
good to know.
That is really good
Yeah.
information.
Let's see. So you mentioned like what happened in 2008. And I wanted to briefly touch on that. I talked to Eric about this. What we've been seeing a lot recently is people that filed bankruptcy in 2008, 9, 10, right around that area timeframe, that they filed their bankruptcy and they had 2 mortgages. In bankruptcy, I'm gonna try and explain this. If you have a second mortgage and it impedes your homestead exemption, meaning that if they were to collect all of it, my client doesn't get all of their homestead exemption, I can value that second mortgage, I can strip it down so that they don't impede the homestead exemption. It's kind of a complex thing. We have to go back and reopen the bankruptcy, but I've had several, I think I shared with you 5 or 6 in the last year, who had filed their bankruptcy, had gone all the way through it. And at the time of filing in 2008, 2009, when their home was only worth 200,000 versus what it was, 500,000 at one time. Then they want to sell their home now, but they have that second mortgage who hasn't tried to collect or anything. We call them ghost mortgages because they've just sat out there. Now the market's hot. I want to sell. Now I'm going to try and collect my second mortgage. I can strip that second mortgage almost completely off if they had filed bankruptcy at that time. Saving, it's bad on the mortgage side, but for our clients, I've saved them $200,000-$300,000 and not having to do that because of the benefit of the bankruptcy in 2008. So if you have a client and you're running the estimated closing or whatever, and you see that there's that second mortgage, if they've mentioned bankruptcy or whatever, we can, and it doesn't have to be the attorney of record, like I can just go in and reopen a case and
I
do that.
wish I would have known that a year ago.
Yes.
Clients, that same scenario that ended up paying it.
Wow.
Yeah. And it's helpful to know that you can go in. Again, a lot of bankruptcy attorneys, we're expecting a lot of people to start dabble when the filings go up, and that's what happens is they learn the basics enough to get the job done, but they don't learn the nuances or what they can really be doing. So,
Good to know.
the last thing that I just wanted to chat about is just go over this scenario I'm dealing with right now.
Dun, 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 dun.
Yeah, so. And and the reason why is because this one kind of has 3 or 4 options that we could be doing for them, and it kind of covers the gamut. This is somebody, so they're in an active chapter 13 bankruptcy. They want to sell their home. We filed the bankruptcy to save the home 2 years ago. They were behind on their mortgage payment. And as you guys know, if I file a chapter 13, I can put arrears into a bankruptcy plan and they can keep their home out of foreclosure. So that's how we save, people's homes from going into foreclosure. So anyway, we filed their bankruptcy about 2 years ago to save the home. Home's now worth, the comparative market analysis that we had done on the home has it worth $900,000. The Zillow, which I know isn't completely accurate, has it between $750,000 and $800,000. They owe $345,000, and the wholesaler agent has offered them $625,000 for the home. So client calls me, says, hey, we're gonna sell our home, we're under contract, blah, blah, blah. Great, send me the information. And I get the estimated closing disclosure showing that my client should get $261,992 from the sale. So I call my client, I said, okay, bad news here. That the wholesaler agent told them, you're gonna walk away with $261,000, and the bankruptcy trustee can't take any of it because it's your home, you have your homestead exemption. Well, Utah homestead exemption at that time was $84,000. So they've been told, one, that they get to keep it all, which they don't. They automatically can keep the homestead exemption, which is $84,000, which leaves $177,000 of what we call unprotected equity. Because anything above your homestead exemption has to be given to the trustee to pay to your creditors. So clients furious with me because I'm delivering the news that you're not getting 261, you're getting 84, because in their bankruptcy, they have $173,000 worth of debt that has to be paid back. So all their equity above their 84 is gone. So I won't go into the nuances of the nightmare, but this client has a few different options that we can do. Their confirmed chapter 13 plan, which when you go through confirmation, you're figuring out how much the client can afford to pay over 3 to 5 years. And, we're cramming down interest rates on everything, trying to figure it out. Their confirmed plan required a return of $38,000. So if they were to just pay off their bankruptcy, they would pay $38,000, not the $177,000. But you have to have permission to do that early, and you have to have permission before you sell your home to do that. So
they wouldn't be able to keep that extra money.
not the way they
What
did
about
it,
it?
but because they hired the right attorney for getting them more money. So in that scenario, a better option for them would have been, one, we have access to hard money lenders that would have borrowed them the $38,000, pay off their bankruptcy. Because even with the $5,000 loan origination fee, and even if you're doing 15% interest for 30 to 45 days, they're still going to save a ton of money. They're still going to walk away with $220,000 versus 84.
Wow.
Doing it that way.
And then selling it on the open market.
Yeah. Yep. Or turn around and sell it to this wholesaler. I mean, either way, we're only paying the trustee $38,000 instead of $177,000. But that's why, as agents, if you contact us even before it goes on the market, we can get rough numbers and be like, okay, this client's gonna have to turn over a whole bunch. What do we need to do? The other option with this client would have been to modify their plan. $133,000 of their debt was student loan debt, but they filed a claim, which means they're entitled to get paid. But since it's a student loan debt and non-dischargeable in bankruptcy, I can motion the court to have that paid outside of bankruptcy. So I can remove $133,000 from there, and the client still would have walked away with 133,000 more. But to do that, I have to file a motion, I have to notice the student loan lender, everything like that, 30 to 45 days. Again, so that's why before it even goes on the market or you sign anything, let us assess and see where we're gonna get the, biggest bottom line. With this client, because of other other situations that they found themselves in, we can also voluntarily dismiss the case entirely. So ultimately, that's what we're doing with this. Go ahead.
Oh, okay, keep going, sorry.
So with this client, rather than go through any of these scenarios, in part because they signed that rep C,
Oh, yeah.
closing off some of our other options. Yeah. Yeah. Open. Yes, this is an agent wholesaler, a local agent wholesaler, but yeah. So with this client, we're gonna do a motion to voluntarily dismiss their chapter 13 bankruptcy. You cannot do that in chapter 7. So once you're in a chapter 7, you're in it. So we're going to voluntarily dismiss their bankruptcy, which we did. You can do that ex parte, meaning you don't have to notice anybody. You just upload your motion and order to the court. They sign it, we can have it dismissed in like 24 hours. So with this particular client, don't hate me for doing this, we dismissed the case, undid the rep C because of some of the non-disclosures that happened when they came and did their high pressure pitch to them. We're doing that, and then we'll list the home on the market and sell it. But then, given who their creditors are, they're just going to hold $25,000 in our trust account, and they've retained us to negotiate those debts as they come back. Because once your case dismisses, your creditors can now come back to you and say, okay, they can file lawsuits or whatever. So given their debt and knowing their creditors, they'll put $25,000 in my trust account, and as those creditors come up, we'll negotiate and pay them off with that.
Smart.
25 grand.
Still get to keep the 200.
I didn't know that was
Yeah.
even an option.
And are those
Yeah.
creditors attached to the house, or are those just random creditors that will be able to claim some of that equity?
Yeah, so these ones are just random creditors, they're not attached. Ironically, this case, we do have, I don't know if you guys know Edwin Perry's law office, I don't know if you've seen him on. So they're a debt collection firm. So in this one, he has attached to this home, which is another scenario that why I want to see things up front, is he attached post petition for a pre-petition debt. So he's violated the automatic stay, which means not only can it's $1,200, but
You'll get it on the
1,200, yeah.
sales. It's recorded.
Yeah, it's recorded for now. So I'm going to go in, one, demand that it be removed, which $1,200 isn't a ton of money, but for a client who's retiring, and this is their retirement, $1,200 is a chunk of money. So I'll be able to undo that. And then the dirty lawyer side of me is going to sue Edwin Perry for having done that and caused damages to my client.
Because
So,
because you touched something to a house
down
that
and
was
dirty.
not like in a repair or a construction.
So
or-
it was a judgment lien. So he had a judgment pre-petition before they filed bankruptcy. He got his judgment.
Okay,
I filed bankruptcy, which means automatic stay. You can't do anything to try and collect. After I filed, he filed a lien with the county attaching to the home, which is an attempt to collect a debt.
right.
The home is property of the bankruptcy estate, so you can't do that. And it's a pre-petition debt. He's trying to collect post-petition.
Okay.
And so to do that, I'll start with a demand letter saying, this is pre-petition debt, you need to remove it.
Mhm.
And even though, so he'll have to have it removed. But then since he's violated the automatic stay, the law allows us to punish him. We can sue him for violating the stay and causing damage to our client.
Can I ask a personal question?
Mhm.
Well, it's a business question.
You wanna see the room? Okay. Sit down, sit down.
Next husband.
Put it on your.
It seems to me like it wouldn't be worth the client to pay you to do all of that work for a $1,200 thing.
The law requires Edwin Perry to pay my attorney fees.
Okay,
On
there we
something
go.
like that.
Thank you.
That's nice.
So,
But I was
He's the
wondering.
loser.
yeah,
Okay.
in this scenario, most laws don't, you have to carry your own attorney fees. In this situation, the law
That's
requires.
legal.
Mhm.
Okay, great.
So in this situation, we'll get rid of the $1,200 and then our judges in Utah will award punitive damages equal to that amount.
Mhm.
So they'll have to pay our client $1,200. So we lose the 1183 off of there. He has to write them a check for 1,200 and then he has to pay my attorney fees for bringing the action,
Ouch.
which is
I like this guy.
between $1,000 and $2,000 will be my attorney fee on something like that.
Okay, great.
So speaking of fees, is it appropriate to maybe ask you how you get compensated for all of this?
On a bankruptcy? Sure. So on chapter 7 bankruptcies, we're one of 2 firms in the state that we do what's called bifurcation. So because our clients come to us in distress, right? Like they probably don't have $2,500 to pay my fee up front. So we will do it for the filing fee up front. So they'll pay $338 up front. And then we will file their case, get their garnishment stopped, get them relief, and then they'll do payments to our office afterwards. It's a huge risk with that demographic of clients, but we have about a 95% collection rate on it. So we continue to offer
Well,
that.
that's fair and equitable. Above
Yeah.
and Beyond.
A lot of states
Wow.
and Utah has the leading case law on allowing this. Judge Anderson, when we're bankruptcy court judges, approved this model. A lot of firms aren't willing to take on the risk. You guys are probably the only person I've really ever shared our collection rate with,
Mhm.
but we have really good collection rate on those things.
Oh,
I wouldn't go to a conference and share that collection rate because I don't want my competitors to
Right.
do that.
So, but are you ever collecting on like when you do the whole bankruptcy and everything settles or whatever, can you get that amount just from that settlement? Or are you seriously?
So you're talking about on this?
Yeah, on what, or whatever you're doing, like,
Yep.
is that
So.
when you get paid normally?
So
or-
on a chapter 7, that's the basic way to do it. Most of our clients do bifurcation
Mhm.
and pay us. On a chapter 13, we are paid. Yeah.
That's fabulous. Thank you.
On a chapter 13, we're actually paid through their bankruptcy plan. So we charge anywhere from $600 to $1,000 upfront
Mhm.
to file the case, get everything together, and that fee range, the range is depending on their circumstance. If they're self-employed, we charge a little more because we have to get all their bank statements and make sure they match up with their P&Ls, things like that. And then the court appoints us a fee based on their income, and we're a creditor in their bankruptcy, so we get paid.
Okay,
And those fees range from $3,500 to $4,200.
okay,
And then when we do these motions, we file a fee application with the court and they approve additional fees,
Mhm.
which these types of cases we like because they're gonna sell, well, not this one. When they actually sell their home and they're sending a lump sum to the trustee. And I file a fee application for something like this is probably around $2,000 to get it all approved and everything. The bankruptcy trustee is gonna send us $2,000 out of that.
okay, so you do get that money when everything's sort of set.
Yeah.
Cool.
Yep.
All right.
Sounds good.
Okay, I will leave some cards. I'm gonna get my other one that has my cell phone for your agents.
Awesome. Thank you.
Just if you guys have questions or you run into something, you're like, hey, this doesn't quite make sense. I'm happy to answer any questions you guys have.
Great.
Or
This
my
was really
office is
informative.
right down here. I'm in this office on Tuesdays and Thursdays.
Okay.
And thank you so much for taking time to meet with
Yeah.
us today. That you did a great job. Thank you so much. Good
Yeah,
to know.
well,
What a
yeah,
resource.
clapping over
Anytime.
there.
Oh,
Golf clap.
but I'll
Any questions? Nope. Okay.
perfect.
Awesome.
I'll leave some cards with Eric that has my cell phone and then, yeah, anytime.
Okay. Thank you.
Okay, thanks, guys.
Thank you. I'm
Yeah.
going awfully fast. Yeah.
Yeah, really appreciate it.
Yeah,
That's
for sure.
interesting.
Super helpful.
Yeah.
Yeah.
More stuff I wish I would have.
Eric, I like your haircut today. Looks really nice.